against Joseph Kramer seeks back child support to the time of the divorce. The problem is that her assertions contradict the divorce agreement. They also contradict counsel investigation, which, while incomplete, indicates strongly that the child resides with his father and paternal grandparents almost exclusively from his birth until late 2009 and more likely spring of 2010. This was not by Mr. Kramer's doing. Counsel has been told by others that Heather Kramer showed little or no interest in her child. Heather Kramer years later took the child, Mr. Kramer states, because he claimed that the child as a dependent on tax. Since then, Heather Kramer has been dictatorial about when the child sees his father. Her written agreement with the child's father apparently means nothing because she has denied in her filings that the agreement meant what it says, asserting she was always intended to be the primary placement parent. This additional support for Mr. Kramer's assertion that Heather Kramer's sworn word means nothing and that what she says unsworn in her proceeds filings is preaching to the gospel. This is, again, what my ex-husband's attorney is saying about me. The irony of all this is that when she's not preoccupied with money, Heather Kramer and Joseph Kramer were perfectly capable of satisfactorily sharing the child's placement and has done so periodically. And when Heather Kramer, through her formal counsel, sought additional placement over Thanksgiving, Joseph Kramer is fine with setting the matter for trial. Holding a hearing on Heather Kramer's motion would be a waste of time and resources since it would have to cover the same material as the trial. Heather Kramer's motion is devoid of information about the life of the child then or now. If the facts prove out as counsel anticipates, Heather Kramer collected support benefits from the state of Alabama for a number of years when the child was not living with her and was in fact being supported by his father and paternal grandparents. This is information she may have not shared with DHR. If anyone should be paying anyone, it should be Heather Kramer, the full-time college student, who was unemployed at the time of her 2005 divorce and who has apparently not worked since. Heather Kramer may be full-time student now at age 27. It's not uncommon with the young people of today for various reasons. That said, her studies appear to be the only thing she's done full-time since her May 31st, 2005 divorce, which I worked at Subway and Ampro and all these other jobs that I've been, clearly they said, filing taxes for. I don't think the government gives you tax money if you haven't worked, but either way. The summary of the relief of his attorney says, the motion filed by Heather Kramer is one of conclusory assertions with no support or authority. The court acted well within its discretion in awarding pendulite placement of the child to his father. Heather Kramer's motion does not contain a single fact or reason for the court to even consider revisiting its ruling. It is due to be denied. Counsel for Joseph Kramer specially reserves a request for an award of attorney's fee to cover the expenses of responding to Heather Kramer's motion. Wherefore, for the reasons set forth, counsel requests the entry of an order denying Heather Kramer's motion. Which is exactly what happened. The judge says that ordered a judge and decreed Heather Kramer's motion for immediate restoration of child custody or visitation will be hereby denied. And that was signed by our lovely judge right there, December 5th. And also I love that it says right here, the court have read and considered the plaintiff's motion for immediate restoration of custody in the matter and defendant's response to the same. She denied it. So it's like after she looked at all the evidence I just presented to you guys, she still denied it. So it's like, Okay, well this is when we finally got a court date. It still had been drug out and drug out. So we filed a petition for the order because she had still never made a judgment from court in May, or April, excuse me. It says, comes now, this is what I sent the judge. Comes now the plaintiff in the above styled caused and petition this honorable court for an order to resolve the custody and issues now pending. As grounds therefore, the plaintiff states as follows, that a hearing with all parties present and testimony taken was held on April 20th, 2012. That the main issue as trial was the custody of the party's minor child. That the minor child had been removed by this court from the mother's custody on about October 31st, 2011. that the plaintiff filed an answer with the court and has been actively trying to regain custody and was denied prior to any evidence being presented on behalf of the plaintiff, that it has been more than 11 weeks since the hearing and more than 8 months since the minor child was removed from the plaintiff, and plaintiff has still not obtained a judgment, that the issues are of such a nature that the excessive delays are a cause of emotional trauma for the mother and the minor child. The plaintiff respectfully requests that this case be adjudicated without further delay and for the benefit of the minor child so that the parties are not in a state of limbo concerning the custody and visitation of the minor child. Well, in the meantime of all these weeks taking forever to judge, after we send that, I go and show the judge's secretary that she has not only a wall photo of her in her courtroom, this is her Facebook page, and she has time to post on Facebook during business hours. It's a very thick packet, as you can see. These are all her postings on Facebook. This is what our tax dollars pays for, the judge to be on Facebook. So, I sent her the petition for her to make a judgment on July 9th. Okay, so she saw the Facebook, saw my order, and she makes this order giving custody to my son's dad on July 11th. 2 days later, she makes this judgment ruling. This matter came on trial for April 20th, 2012. The issues before the court were the claim of the Department of Human Resources and the placement and support of the minor child of Gavin Kramer. At the trial, Joseph Kramer called witnesses to testify, offered his own testimony, and introduced exhibits into evidence, which he did not. Heather Kramer testified and called a witness to testify and had a buttload of evidence no one looked at. So, she says that placement and support of Gavin have considered the admissible evidence. The court, in this opinion, that primary placement of Gavin Kramer, which has been with Joseph Kramer, pinned to light, should remain with Joseph Kramer. So she's saying he should stay with his dad. Primary placement of the party's minor child, Gavin, shall be with the plaintiff, Joseph Kramer. The defendant, Heather Kramer's secondary placement with the minor child is followed. So I get to see him the first and second weekend of each month, from the time my child is in school until 6. Then I get him on some holidays. You know, I've had my child nearly his whole life and now only get to see him twice a month. So you can imagine the heartbreak of that. But then also it says, Heather Kramer shall pay child support to Joseph Kramer, which he has never paid, in the amount of $271 per month. Mind you, I'm unemployed. The child support has been calculated in accordance with Rule 31 of the Alabama Rules of Judicial Administries. The parties shall each pay 1/2 of Gavin's activities. So the judge signs this saying under the Alabama regulations I should pay that, which is crap because that isn't the regulations if you don't work. So then I file a motion to alter, amend, or vacate order filed. So I say, Heather Kramer asserts the documents presented by evidence the defendants were not complete. The Exhibit A, as referred to in the divorce decree, was missing. Heather Kramer was ordered to pay child support in the amount of $271.47 to the defendant. According to our calculations of the Alabama Child Support Guidelines, the amount of child support paid by the plaintiff should be $245. Child support guidelines are attached. The minor child is currently attending Alexandria Elementary School, which he has been since he was 3, and that the final degree filed in Etowah County on May 31st, 2005 stated both plaintiff and defendant have true joint custody of the parties. The plaintiff respectfully requests from this honorable court that true joint custody continue to allow the minor child to continue to be enrolled in Alexandria School District. And that was the child support.